We have major breaking news out of the United States Court of Appeals for the Second Circuit out of New York City. I'm not even going to do an introduction. I'm going to cut right to the chase on this one. It's such a big deal, and I've been out of town for much of today, so I got to go fast. Bottom line is, in the decision of Handbook against basically the state of New York, a series of decisions was entered today by the U.S. Court of Appeals for the Second Circuit. This deals with a preliminary injunction on three general areas. That would be New York State's new licensing requirements as to when you can get a license to conceal carry a firearm in the state of New York. That would involve also a second category of issues in this case, sensitive locations, which is the sensitive places issue, also known correctly in my view as government-mandated gun-free zones. And last but not least, this involved the so-called vampire rule or the restricted locations rule, which says basically that you have to get, at least the law says, you have to somehow get permission from a business or place that's open to the public for business in order for you to walk in there with a gun. And if you don't know the owner of the random convenience store on I-95 or I-94 or whatever it is in New York, then you cannot go in there. So here's the bottom line. This was the exact same decision was rendered today by the Second Circuit Court of Appeals on these very issues that were rendered over a year ago in the prior Handbook case. You may recall that the Second Circuit issued an order that said that the so-called vampire rule or default rule that says that you cannot carry guns into a place that's open for business to the public without first getting permission from the owner, that is unconstitutional under the Second Amendment. That is unconstitutional under the Second Amendment is exactly what the Second Circuit ruled yet again after the Rahimi case, because the Handbook decision was first and foremost decided before the Rahimi case, and then the U.S. Supreme Court decided the Rahimi case in June of 2024. And what happened was this case, the Handbook case, was sent back to the Second Circuit by the U.S. Supreme Court to be redone, reassessed in light of the ruling in Rahimi. And the bottom line is that this three-judge panel basically issued the same exact order that it did prior to the Rahimi decision, which reaffirms what I've been explaining to you and to judges and other people in my various presentations, that the Rahimi decision does not alter the Bruin analysis. All the Rahimi decision constitutes is an example of the application of the Heller-Bruin methodology. And the fact that the Second Circuit Court of Appeals issued the exact same ruling before the Rahimi decision as it just did today after the Rahimi decision proves my point that they did not think Rahimi changed any part of their analysis. Now, with that said, this court is not an anti-gun court like we see in the Fourth Circuit out of Virginia and Maryland, like we see out of the Ninth Circuit in California and Hawaii and so on. The Second Circuit Court of Appeals is not an anti-gun court in the sense that they just hate guns and are always going to rule against gun. The problem with the Second Circuit Court of Appeals, in my view, is that they're inexperienced with gun laws. They're inexperienced with guns as a technology. So even though I think this three-judge panel, and I'm friendly with members of this panel, by the way, even though I think this panel tries to get the law right, I think they don't get the law right. I don't think they understand how this really works. And I don't think it's for a lack of effort. I think it's for a lack of understanding. I think they just didn't nail this. So there's a lot of mistakes in this opinion that we're going to go to in future videos as well as quickly today. So the bottom line is this was a challenge to the New York State licensing arrangement that basically says, hey, look, you can't carry a gun in the state of New York unless you go through and turn over a bunch of information to these licensing officials so they can make a decision using their discretion as to whether or not you're entitled to carry a gun. Now, this is clearly not allowed under Bruin that says the only way a shall issue permitting regime or a permitting regime can be constitutional is if it provides for a very narrow set of standards and objective criteria with narrowly applied and no discretion. And nevertheless, this court here today allowed for robust discretion and the allowance of, let's say, personal references and other information that the assessor of the permit is allowed to consider. This is clearly wrong under the Second Amendment law. It's clearly wrong under NYSERPA versus Bruin, but the Second Circuit seems to think it's allowed, and we will break that down in future videos. But the bottom line is, it said that the New York State licensing system as currently constituted is appropriate, is approved, and consistent with the Second Amendment, with two exceptions. The first is they specifically say, as I read this case, that the good moral character component of the licensing rule that says you have to have good moral character to have a gun, to carry a gun, they equated that, as I read this decision, which is 240 pages, that's right, 240 pages, they equated that with being dangerous or not being dangerous, so they did in some ways narrow the scope of when you can be disqualified to you can't be dangerous to yourself or to others. So in that sense, this is a slight positive step forward, although I think they still got that wrong. But beyond that, they also said that you have no obligation to turn over social media accounts, because under New York law, you are required to turn over your social media accounts, including anonymous accounts, to the government for them to review your postings. The court here today at least said that that was verboten, not allowed. You don't have to turn over your social media accounts and that information to the government in order to get a concealed carry permit. So that is at least one nice win under the Second Amendment. Beyond that, in addition to the fact that they upheld, they upheld their prior ruling that the so-called vampire rule was unconstitutional. So they said specifically that the law in the state of New York that says you can't go in to places that are open to the public for business without first and foremost getting consent to carry your gun in those places, that is unconstitutional. They said that's not how the world works. The presumption is you carry your constitutional rights everywhere you go, and there's no historical tradition in American life that says you have to first and foremost get permission from places that are open to the public to carry a gun. So the good news is they knocked out the so-called vampire rule again in the state of New York, and they knocked out the social media requirements, and they narrowed down the scope of what constitutes a good moral character to dangerousness. So those are all positive developments. But beyond that, the court then goes totally off the rails, and in addition to upholding the rest of the licensing standard and giving away too much discretion to licensing officials, that's totally not allowed, but they allowed it. We will break that down in a future video because we're going to have to get geeky on that one, and I just want to give you the highlights today on this particular video, on this particular decision. Again, it's a 240-page decision, so there's going to be a lot to digest and explain in future videos, which I will do. The next thing you got to understand is they go through the list of so-called sensitive places. So the places where they said you can ban guns includes public parks, with a possible exception for parks that are in rural parts of New York, believe it or not. But urban parks and urban areas, you can ban guns, which makes no sense. Nevertheless, that's what they said. They also said you can ban guns in zoos. You can ban guns in addition to zoos in places where you can consume alcohol, which makes no sense because every Greek diner that you have breakfast at in New York City can serve alcohol with a liquor license. So I don't know how that works, but that's what they said. Then they go on to say that they can ban guns in theaters, conference centers, and banquet halls. They also say that you can ban guns in places where there's First Amendment gatherings and so on. They do say specifically that the law against banning guns in churches and synagogues and the like has kind of been amended, and they're not going to get to that because they said it was previously amended to allow the pastors, the priests, the rabbis to allow people to carry guns and designate people as the security guards. So they basically said that what they did is they punted on that one issue. So the bottom line is, overall, this is a short-term loss for the Second Amendment. This was up, by the way, on a preliminary injunction standard. This is an interlocutory appeal. So what I think should happen if I were the lawyer in this case, I would basically skip, seek, and cert from the U.S. Supreme Court. I don't think this is going to be the right posture for it. The Supreme Court has shown no appetite to hear a Second Amendment case on a preliminary injunction basis on an interlocutory appeal. So probably if I were the lawyer in this case, which I'm not, but I probably would just go back down to the district court and try to get a final judgment as fast as possible on summary judgment, get a final judgment on these various issues, and take it back up and try to get the Second Circuit to hear the case fast, and then get back up to the U.S. Supreme Court in the next year or two. But again, they may seek cert from the U.S. Supreme Court, but I don't think that will work. So bottom line is the Antonyuk case has been decided yet again. They did exactly what they did before Rahimi. After considering Rahimi, they did the same thing. And again, they got a couple things sort of favorably right. Certainly the vampire rule is a very big deal because you got to understand that is a rule, that default provision, that restricted location that says you can't bring a gun into a place without getting a person's permission first and foremost, where that place is wide open to the public, would have basically made over 90% of the state of New York for a gun-free zone as a matter of law. And this is a very big deal because this is a theory that the anti-gun movement, as best I could tell, came up with in the last 5 to 10 years, and it's gotten no traction. I think there's only one decision in the Ninth Circuit that upheld it in part with respect to Hawaii, but overall, it has not gotten traction, and that is very good news. So anyway, that's where we have it. We will break down this anti-Young decision more going forward. Overall, again, this is a short-term loss for the Second Amendment, but I think there's a lot of mistakes by the Second Circuit Court of Appeals that will be used as teaching points down the road. And as I keep telling you, and I've said it in many groups in the last 6 months, if President Trump is reelected and becomes the next president of the United States, I think a lot of these cases are going to get fixed and fixed fast by the U.S. Supreme Court. That is my hope, and I think that's my prediction. I feel pretty good about that. But again, we're going to find a lot more about where this country is heading and our Second Amendment rights are heading over the next few weeks. So there you have it, folks. Hope you learned something here today. Breaking news out of New York City. And make sure you follow me and subscribe to this channel. Don't forget to follow me on X at 4 Boxes Diner. And we will see you again very soon here at the 4 Boxes Diner.
Orders up. Table 2A.